allows us to invite every year a leading scholar in Arabic and Islamic studies to visit our department for a week to interact with our faculty and students. And we've been very happy to be able to host and invite leading scholars such as Bilal Orfali, Nasser Abad, Fred Warner, Doris Abu Said, Zayed, and more recently Marina Roscoe, Petra Sishwasti, and Ricky Nasser. And this year we're honored to have with us Dr. Bilal Orfali, who is the Sheikh Zayed Chair for Arabic and Islamic Studies and the Chair of the Department of Arabic and Near Eastern Languages at the American University of Beirut. Dr. Orfali earned his PhD from Yale University in 2009, writing a dissertation on the art of anthropology and Arabic and He specializes in Arabic literature, Sufism, and Quranic studies. He co-edits the Abhas Journal, Bill's series Texts and Studies of the Quran, and serves on the board of several journals, book series, and academic projects across North America, Europe, and the Middle East. He is the author and editor of more than 20 books on Arabic studies. He is quite prolific, and he puts us all to shame with his publications. His recent publications include Life Upon Light, published by Bayard in 2019, Insatiable Appetite, Food as Cultural Signifier in the Middle East and Beyond, also by Bayard in 2019, The Anthologist's Art by Bayard in 2016, The Book of Noble Character, 2015, The Comfort of the Mystics in 2013, Sufism Black and White in 2012, In the Shadow of Arabic in 2011, and just last week his most recent book, co-authored with his comrades, came out on the Mohammed of Al-Hamadhani. I was quite interested to know that his first degree was in mathematics. He got a BS, Bachelor of Science in Mathematics, and then an BA and MA in Arabic language and literature from AUB, and then his MPhil PhD from Professor Orfali will be delivering 2 public lectures this week. Tonight is the first on Islamic thought and literature, case studies from Tanukhi and Hamadhani. And then on Tuesday, they'll be giving the second public lecture in Arabic at Bayard Hall in our Tahrir campus with the title Walking in the Steps of Poets, Poetry Themes in Early Sufism, or على فضل الشعراء في نهج شعرية متطورة. So without further ado, please join me in welcoming Professor Orfali to this.
Good afternoon, everyone, in the room and virtually as well. I would like to start by thanking my friend, Dr. Hamadhani, for this general introduction, and the faculty of the Department of Arabic and Islamic Civilizations for this invitation to give the Dutch lecture series for this year. This is a great honor, especially since the Dutch served as the president of my own institution, the American University. This invitation carries more meaning also to me, as I have not lectured publicly for a long time. The most forgot how to do that. I'm out of practice. And it's wonderful also to be able to travel again, and of course to visit Cairo again, a city that I hold very dear. My own research is in Arabic. I've always had an interest in many Islamic disciplines, Islamic law, Quranic studies, Sufism, in Hadith and literature. And one of my late professors once told me, you cannot do all these things. You have to choose. But if you want to do all of them, do Arabic. And he was right. And in my research in general, I try to build these bridges or uncover these bridges that are already there between these Islamic disciplines to show that they're connected, but also a nuanced understanding of any of these disciplines cannot be achieved in isolation from the others. You need to look at them in their totality and to look at these bridges to understand each and every one of them. And this is what I'm trying to do. And in this visit to Cairo, I thought I'll give 3 minutes. One, this one is on on the links between literature and Islamic law, in particular. And then another graduate seminar will be on the link between literature and scripture, specifically Quran and Hadith. And the third one is a public lecture also on the link between literature and Sufism. So, adab is there. In all these three events, when we talk about adab, adab is our hero. I feel embarrassed to talk about adab in front of my friend Adam Talib, who was adab much more than me. And I'm afraid I don't have a good definition of adab. There is no, in my opinion, one good definition. So I might not be able to give it this definition or define the term to you in a way that satisfies all of you. But I hope to convey through these lectures what does an adib do. This is something I'm very concerned with. So back to the subject of this talk, Islamic law and literature. The lecture is about case studies from Tanukhi and Hamadhani. Tanukhi died in 398 and Hamadhani died, Tanukhi died 384 and Hamadhani died 398. Of course, Hijri dates. So that's 994 and 1008. So I'm going to select case studies in order to show this link between literature and because this is my methodology. What is the role of Islamic law in literature? And reflexively the role of literature in Islam. I set about to answer this intriguing question with reference to two of the most acclaimed storytellers in early Islamic history, Abu Ali al-Muhassin al-Tanukhi and Abu Fadl al-Zaman al-Hamdani. Both names were adibs of Arabic Islamic culture and had something to say about both law and literature, though not necessarily in ways one might expect. Theirs were not stories about the literary themes of law. They were not like dramatizations of fictional cases after the style of, say, Harper Lee's To Kill a Mockingbird, a classic American novel that featured the brain of subsequently questionable, lawyerly protagonist Atticus Finch, addressing fundamental questions of racial and criminal justice. This is a common theme in American literature, if you're familiar with it. I can think, of course, of Diana Jones, for example, in this novel, An American Marriage, but also of the many Netflix series that expose the judicial courts in the US. Think, for example, of Orange is the New Black. So theirs are not like this, but stories in the works of Tanukhi and Hamadhani featured something more mundane, having to do with legal themes in literature, quarrelsome traders, greedy litigants, and jealousy in the judicial and royal courts. These stories delivered a moral for their place and times, as fiction often does. The literary form used to impart moral lessons in the medieval Islamic world was narrative, and both Tanukhi and Hamadhani excelled at presenting such lessons in their works. But these stories also delivered important lessons about the law, or the popular perception of it, through the incidental presentation of judicial procedure. Because these descriptions of courtroom procedure are incidental to the narratives, historians can confidently use such descriptions to supplement the relatively abbreviated and prescriptive account of judicial procedure in more conventional sources of early Islam. So I claim that not only literature uses law, but also law uses literature as well. It's a big claim. I'll try to demonstrate this. Scholars in medieval Arabic Islamic societies regularly compile literary anthologies as a practice dedicated to cultivating adab, a term only loosely translated as literature. Adab works circulated in informal or semi-formal literary networks that function largely alongside the formal school systems of madrasas and hotel. An adib The cultural adept who produced or fluently engaged works of art often drew on various fields of scholarship, as wide-ranging as poetry and grammar, history and prosopography, theology and philosophy, mysticism and Quranic sciences. Though less appreciated among scholars of literature today, no. The result is a written corpus of social commentary on a complex nexus between intellectual and religious ideas, or ideals, as well as social and political relations in early Islamic societies. For each, the adil acted as both scribe and critic. Some of these religious ideas and institutional relations concern the social function of Islamic law and procedure, and of the judges who helped produce them. Compilations of judicial biographies called Akhbar al-Qadha and of the judicial manuals called Adab al-Qadi, for example, often recorded applications of judicial procedure and outlined courtroom etiquette that judges were advised to observe, even as they helped devise them. Adab works can provide windows, and this is a claim, into some aspects of everyday life in Islam's earliest periods, for which records are otherwise often sparse. Historians of law and of literature alike often want to know how everyday Muslims experienced life in markets and mosques, as well as in the core sites of mediated conflicts, the royal and judicial courts. Literature provides insight into that world in a form of plausibility, even if not verifiable truth. That is, literature provides access to the extraordinary as a lens through which to view the ideals of the ordinary. Even when it is self-consciously stylized narrative that depicts the most sensational episode worth preserving, we start with the premise that literature cannot help but reflect ordinary outlooks on often extraordinary disputes. I'll start with the Tanukhi, so I have two heroes, Tanukhi and Hamadhani, and I'm going to start with the Tanukhi, just because historically. In addition to producing literary works, Abu Ali al-Muhassin al-Tanukhi was a prominent judge in Abbasid Baghdad, hailing from a well-known family of Mu'tazili rationalist judges. His father was a judge, his grandfather was a judge, on his father's side and his mother's side were all judges. Of course, he never knew sympathizing. He was himself also a prominent Mu'tazili rationalist theology. He was a Mu'tazili himself. His theology was reflected in his writings. Tanukhi's writings deliberately include certain religious and ethical themes, and I'm not going to go into how this is the case. But rather than composing explicitly theological or legal works, his written legacy presents him chiefly as an adib. We don't remember him as a Mu'tazili anymore. We actually remember him only as an adib, a literary scribe and critic who provides rich insight into law and procedure of his times. Tanukhi is best known for two literary works, the Nishwar al-Muhadara and the Faraj al-Sheikh. The Nishwar is partly preserved, not fully, and I'm going to focus on the Faraj. The example I'm going to choose these stories just because they're short and I can present them in the lecture, but there are dozens of similar stories in both the Nishwar and the Muhadara. And I hope one day to write a book about this link to Islamic using these stories. Faraj al-Sheikh, also let me introduce you to the genre a little bit to make sense of the stories. Al-Faraj al-Sheikh is arranged into chapters according to subjects and collects stories that reflect a literary trope, after which the book is titled Relief After Adversity. Faraj al-Sheikh. Tanukhi's works bear all the hallmarks of other adab works, but can be read for insight into judicial procedure. They are written meditations on moral and social upbringing, intellectual education, and entertainment. These are the hallmarks of it. And they also provide useful insight into the social and political norms of Islam, including norms related to settlement and the social significance of Islamic law and procedure, the theme to which we now turn. My case number one is the case of Abi Ali Ahmad As-Suli and the promissory note. This is how I got it. The story comes from an episode that Tanukhi relates about himself from the time he witnessed his father, who was a judge in Moscow, handling an inheritance case with which the younger Tanukhi was later to become intimately involved. The year was 335-946, when Tanukhi first observed the events unfold as a schoolboy. So he was a schoolboy, and he relates the story. Tanukhi said, I was in Basra at a stage where, nearing adolescence, I could understand, memorize, listen attentively to lessons, and well grasp what was happening. When the following events unfold, this introduction is important. He wants to say, I was aware of what was happening. Abu Bakr Muhammad bin Yahya as-Sunni had died there, presumably, that during the month of Ramadan that year, and had designated my father, the judge, as a recipient of his estate, having noted in his will wasiyah that he had no heir. 3 young brothers came to my father, all in the worst of conditions. The oldest of them was called Abu Ali Ahmad, the middle one Abu Hassan Muhammad, and the youngest Abu Al-Qasim, all sons of Muhammad al-Tammam. They informed my father that their mother was a relative of Abu Bakr as-Sunni, and that they should have inherited from him by virtue of a relationship to him. So he had, they should inherit. They then proceeded to specify what relationship and connection to him by the deceased. So what would the judge do? My father demanded that they produce evidence of that claim to him in the form of 2 reliable witnesses, and I highlight this sentence, before he would distribute to them the excess funds of the 1/3 remaining after paying off the debts from the estate. So they went about doing that, going around to and fro for months to solicit the testimony, the shahada. Before finally coming back to my father's door, Tanukhi went on to describe the setting of what came next. The Suli brothers often used to sit with me in my school. Tanukhi being friendly with my teacher, playing with me, getting close to me, and asking me to present their case to my father through petition after petition that they gave to reach the judge, befriend his son. No. One day, the eldest of them, that is Abu Ali Ahmad bin Muhammad, said to me, if God extends your life until you take up the judgeship and you become like your father, the judge, the qadi, in stature and in wealth, and if I were to come to you, what would you give me? I said to him, out of youthful innocence, and as came to my lips, 500 dinars. He said, give me that in writing. I became shy and said nothing. He said to my teacher, tell him to write it to me, for me. Write it down for me. The teacher said to me, write it down for him. And my teacher and Abu Ali dictated to me a document to that effect, which Abu Ali then took. So there's the road. Only a few days passed until the testimony was heard before my father استبدت لهم الشهادة عند أبي, confirming the validity of their claims to the maternal relation to the deceased and their entitlement to the inheritance based on it. So they won the case and they took the inheritance. My father had sold the estate, paid out the debt, divided the remaining third, and kept the rest of the money. So he ordered that the latter sum be delivered to the Sunni brothers. Had its receipt by them witnessed, أشهد بقبضه عليهم, and they left. That was the end of the story for them. Though the young Tanukhi was to encounter one of the Sunni brothers again, some 2 decades later, when the younger Tanukhi had become a judge in Ahwaz. He was to encounter the oldest Sunni brother again, Abu Ali al-Sunni, the same one who extracted the promissory note from the school board to pay 500 dinars should he one day become a well-to-do judge. Managed to track down the boy turned judge in the year 356, 20 years later. He came to him from Baghdad, looking disheveled, and informed the judge that he needed a large sum of money to repay his debts from Iran. Apparently, the Sunnis were constantly in need of money. Confused at first, the judge Tanukhi only recognized the man after he produced a document showing the judge his old school, the boy scribbles. As soon as he saw it, he remembered the conversation, praised God profusely, and said that debt is an obligation. I have to pay it. A substantiated, actionable claim, haq, mar'i, wakid. He did not have 500 dinars, which was a considerable amount of money. So instead, gave the oldest Sunni brother a house, clothes, and 300 silver coins, dirhams, impressed upon the town officials to give the man 10 dinars plus another 200 dirhams immediately, and then gave the brother a position that would entitle him to receive 2 dinars per month until the debt was paid off. When Tanukhi left his post in Ahwaz to accept another post, the succeeding judge confirmed his decision and continued to ensure the payments went to the Sunni brother. Thereafter, to make a long story short, the brother abused the position and took advantage of Judge Tanukhi, constantly holding him hostage to the debt until it was satisfied. Sorry for the long story, now we come to the analysis. It was a lesson that one should repay debts and show kindness to positions of power, even to those showing unkindness. The story is certainly a tale that fits well within the literary genre of Hafaj. The Sunni brothers had first operated to get what they claimed to be their share of inheritance from a man whom they clearly did not know well, but to whom they could claim some relation. But the oldest Sunni brother took it one step farther, scheming to get a promise of even more money and then cashing in on it 20 years after the fact. He was delivered from hardship, not by any good deed of his, but by the generosity of the protagonist Tanukhi, which prevailed over the antagonist's bad behavior. It was also a lesson to be on one's guard in legal proceedings, and not to agree to uncalled for payments, especially not in writing. If one was not prepared to deliver, it was a self-praising lesson too, where the author Tanukhi used himself as a model to instruct the reader on the value of upholding one's promises and meeting grubbiness with kindness. There's a lot to learn from this story. Notable here, for my own purposes, are the incidental uses of procedure that Tanukhi references throughout the stories. 3 are worth highlighting in this story. First, Tanukhi's father, who was responsible in his capacity as a judge for disposing of the estate of deceased who left no heirs, required evidence in the form of testimony of at least 2 upright witnesses to a subsequent claim of familiar relations in order to satisfy the demand for inheritance. This rule fits within the norms expressed by the famous legal maxim of procedure. The claimant must produce the evidence and bayina ala al-mudda'i, that's legal. To establish a claim or right, usually juxtaposed against the respondent, who must swear an oath to deny the claim, وَيَمِينَ عَلَى الْمُدَّعَى عَلَيْهِ. What is notable is the fact that this legal maxim applied to situations as here, even when there was no counterclaimant or opposing litigant. Second, the story shows that it was commonplace to have witnesses verify receipt of money to which they were entitled. That is, Tanukhi's father not only requested the two upright witnesses prove the claim of entitlement, but also had two other witnesses attest that the claimants had received the money and had satisfied the claim, just as the earlier judge had required witnesses to attest the satisfaction of the judgment. Such procedure would have been necessary in a society where court proceedings were not always public, and the records not otherwise preserved automatically by an official notary or the like. During that time, court sessions were regularly held in the home, the mosque, or the marketplace. The witnesses' attest adds finality to the case, particularly when the judge did not have a simple system to which he could appeal for recourse if accused or failing to satisfy such claims. To be sure, there was no valid royal court system by which the litigant injured by an official's action could appeal to the executive. The attestation of the judge's satisfaction of the claim would insulate him from frivolous claims. As it turned out, he might well have needed such insulation when dealing with the lives of the Sunni brothers. Third, written evidence of financial obligations was clearly common and clearly actionable, despite a general assumption in the field that early Islamic history exhibited overall antipathy towards written evidence. Evidently, even as a schoolboy, the young Tanukhi had reached an age at which he was legally subject to liability for his actions and able to engage in financial transactions. Accordingly, his older judge, Sheikh, recognized the obligation as soon as the oldest Sunni brother presented to him the document, written in the younger Tanukhi's own hand. Here, we notably see the use of written evidence, despite the idea gleaned from the legal sources that oral evidence occupied a primary, almost exclusionary place. The written evidence in early Islam. This tension between the written and the oral, we're going to see in the next case that it is present throughout Tanukhi's works. In all of these ways, we see the common ordinary court procedures in everyday life as depicted in Tanukhi's literary way. Now, case number 2. It's much shorter. It's the case of the falsely accused slave woman of Vizier Ahmad ibn Bilal. In this episode, Tanukhi tells a tale involving the threat of false testimony, even with written and testamentary evidence in the form of witnesses. Not even the ordinary procedures of verifying written evidence were facing. It was a lesson that judges were to be constantly vigilant in uncovering causes for doubting facts and in asserting the truth through increased procedures of seemingly probative witness evidence. The episode unfolded around the turn of the 3rd, 9th century. So Tanukhi is not a witness, he's relating this from his life. A slave woman belonging to the Caliph's vizier, Ahmad ibn Bilal, was accused in sworn documentary evidence of committing fornication, zina. It was up to the presiding judge, Ibrahim ibn Abbas al-Sudi, to determine what actually happened and whether the slave woman was to be subjected to the most final of punishments that the vizier wished to impose, the death penalty. According to the judge, the vizier produced a document, Ruqa, alleging that his slave woman had slept with someone else. To verify its contents, he called on 2 of his trustworthy servants to bear witness to the document. Is this document true? While they did not initially attest to the contents of the document, eventually they did. Perhaps it was their delay in attesting to the contents of the document that raised doubts for the judge. Moreover, he came to find out that the process of securing their testimony was questionable to say the least. As the vizier reported, he told him, and now I quote, the vizier spoke, I called the two servants and asked them both about the affair, which they denied, فَإِنْكَرَاهُ. So I threatened them. They were steadfast in their denial. So I met them and presented to them both an instrument of torture and then they confessed to everything in the document against the slave. But I did not eat a bite of food yesterday or today without being preoccupied with putting the slave woman to death. She deserves death. On hearing this, the judge looked at the Quran to see if it could offer any guidance. Opening it to a random page for that purpose, a process by the way called iftiham, we call it istikhara nowadays, his eyes fell on the verse, O believers, if a sinner comes to you with a piece of news, then verify it. يا أيها الذين آمنوا إن جاءكم فاسق بنبأ فتبينوا. That verse, the judge said, gave me doubt about the validity of the story. After securing the vizier's permission to take the matter into his own hands, the judge used a different type of procedure. So he rejected the first procedure. So he used a different type of procedure to ascertain the probity of the evidence. He separated the witnesses until one of them confessed that the wife of the vizier gave him 1,000 dinars in exchange for his testimony against the slave. He proved it by producing a cash-laden envelope with her seal. Eventually, a second document from the woman arrived, informing the judge that the first accusatory document was of her doing it out of jealousy because of the slave woman, that everything in it was false, and that she forced the two servants to testify falsely against the slave woman. In that way, the slave woman was innocent. She was saved. While the social moral of the story might have been to warn men away from plights caused by the wife's sexual jealousy, the legal lesson to be gained from this story was more directly procedural than the others. Judges should be especially attentive to ensuring that testimony, whether written or oral, is authentic and probative. In fact, the story reflects an ongoing problem in early Islamic societies and the centrality of procedure in anti-Semitism, and ever-present specter of false testimony, shahadat al-zur, that was a big problem, which was a threat so great that it appeared in popular literary stories like this one to warn against it generally and to caution judges implement procedures designated to root it out. I turn now to the other hero for today and the last story, Al-Maqama al-Shamiyya of Al-Hamadhani. Let me introduce the genre first. Maqama, or plural maqamat, refers to a native genre. You have the Maqama al-Shamiyya in the I thought to distribute it because it's not actually published. And we see why. Well, it's published, but not with the Hamadhani published. It's the common edition. So, Maqama or Maqamat refers to a native genre with fictional Arabic prose literature that has played an important role in Middle Eastern and global literary history. Invented in Arabic in the 4th and 10th century in eastern Iran, maqamat are collections of picaresque tales that narrate the various adventures of the trickster's travels across cities of the medieval Islam, casting the exploits and speech of its characters into flowery prose. Maqamat, and you will see it's very flowery prose, full of rhyme, full of sajda. Maqamat tales are often ironic, parodic, and darkly humorous tales which have proven themselves remarkably clever at capturing the attention of medieval audiences amid modern readers and critics. They often mock our aspects of the society or our knowledge and perception of literature, religion, science, and philosophy. I'll continue with this theme in the seminar that I will give. The first person ever to author a maqama, and that's very exciting, right? Think of the first person who composed this sonnet, first person who composed an epic. This is very rare in literary history where we can actually track down the first who does this. So the first one was Bayard al-Hamadhani, a scholar who would later be known during his life as the marvel of the age, Bayard al-Zaman, for his extraordinary eloquence and creative powers. Born in the year 958 in the city of Hamadhani in western Iran, he spent most of his adult life in the cities of Nishapur and Iraq in eastern Iran and Afghanistan today. The Maqam al-Shamiyya of Bayard al-Zaman has long been overlooked as a result of the decision of Muhammad Abdu to remove it from the first modern published edition of the Maqam. He thought it's inappropriate. So it was ethical reasons. Thought another Sheikh should not publish this. Maqam al-Shamiyya is composed of one long episode of two wives complaining before a qadi about their husband. You automatically know it's going to be scandalous. Two wives talking about their husband in the court is not going to be good. The action of the maqama can be divided into two main parts, in which each wife tells her story to Isa ibn Hisham, who is the judge. And let me warn you, of course, these are fictive characters. Abu Fath al-Iskandari and Isa ibn Hisham. And there is fake Islam, frivolous Islam at the beginning, Haddathana Isa ibn Hisham. So, the first wife demands her dowry matter be returned to her. The husband claims that the wife is at fault. She does not deserve this money, and paints his wife in the ugliest of physical descriptions. However, he readily admits to the qadi that he nonetheless took the woman to bed, thus consummating the marriage. Because in law, if he consummates the marriage, he has to pay the full marriage. Otherwise, he pays only half of it. She wants her full marriage. So he says, قبل كنت أرمي بالنعش قال أعز الله القاضي صدق عن ذلك وأنا غريب من أهل الإسكندرية فوالله ما أثقلت لي ولدا ولا أشبعت لي كبدا ولا عمرت لي خرابا ولا ملأت جرابا قلت قد تبطلتها؟ قال نعم ولكن فمن غير بالغ وثدي غير ناهد وبطنا غير والد وعيبا غير واحد وريقا غير ريب وطريقا غير ضيق. He said, may God save the judge. Why the gift? What's the reason? I hail from Alexandria. I'm a stranger in this region. This woman never fastened the peg of my tent to the ground. No, through her was ever my heart's desire found. Not once did she make my wasteland blue. Nor did she fill my sack with food to consume. I then turned to him and said, but you took her to bed. Yes, he replied, but her breath was rank, her chest was as flat as a wooden plank. Her womb would surely prove barren. Countless are the veins she earned. The water from her mouth afforded no delight, and the path to her pleasure was no longer tight. The wife's testimony complicates matters. She has to reply. Think of maqamat also as literary debates. Who is more eloquent wins. So she has to reply. She's not going to accept this. She alleges that she was extremely beautiful at the time of her marriage and accuses her husband of ill-treating her and abusing her. Moreover, she claims that her husband has violated the marriage contract by being impotent and the passive partner in the same-sex قال أيد الله القاضي هو أكذب من أمله وأسمج من عمله وأكثر في اللؤم من حيله وأشد في الشؤم من دغله وأفسد عشرة من أسفله والله لقد صرفت من فمه صقرا ومن يده صخرا ومن صدره سم خيار لا ينشأ الخيار ولقد زفرت إليه بدنا كالدباج ووجها كالسراج وعينا كعين النعاج وثديا كحق العاج وبطنا كظهر الهلاج وخصرا ضيق الرداج خشن المنهاج حار المزاج صعب العلاج ولكن كيف أليم ولا ينجز ما يعني وهو يجد ويجتهد لو لم يخله الوطن. She said, may God offer you, O judge, his support. This man's falser than his hopes and means and viler than his deeds. He is more blameworthy than his tricks and deceits, and more ill-omened than his base conceits. In short, I'd say, he's a worse friend than his own butt cheeks. And from his mouth, for me, there was only stained water, and the rock was all his hands were offered. Tinier than a needle's eye was his largest. It weighed no more than a carat, maybe less. Before we were wed, my skin was emasculine brocade, my face was enamel, eyes were blue, and my breasts from ivory cups made. My belly was as flat as a racehorse in full stride, while my waist was cinched tight. Though suitably wide, down below I possessed a native heel that was different from even skilled butlers to tea. But how could a child from him be born when he couldn't do what he had sworn? For though he struggled and strove, his stubborn pen refused to move. I still think about the best way to translate this text. It's not easy, because rhyme in Arabic works very differently than rhyme in English. In Arabic, it's actually nice. In English, we look at it as being archaic. So I still struggle with the musicality of this. But we keep, my co-author and I, Boris Mohamed, are now translating them. So we keep changing these translations every time. I think we have 5, 6 different ways to translate each of them. In anger, the man then described that he was so potent that he was able to have intercourse with her 20 times in a single night, and through such rough treatment caused her to miscarry. This would mean that the wife was, in fact, fertile, invalidating his initial claim that she was barren. Seizing upon this fact, the wife insists that all she said was true, whereupon her husband accuses her of having tricked him, and he insults her in front of the court. The scene concludes without Isa and Hisham offering any judgment. The second wife then begins her story of commitment. Unlike the first wife, she demands a stipend, nafaqah, from the judge, or that she be divorced from him. Isa ibn Hisham, the qadi, sets the amount at 100 dirhams per month. The husband answers that the judge does not recognize his fault and has unfairly offered too large a stipend. However, the woman insists that she needs the money for her daughters. So the qadi in this situation pays the stipend himself. When the two return seeking more money into one, the qadi dismisses them, threatening them with a judgment of divorce and exercising his right not to judge in the case. After Isa and Hisham dismisses them, the man recites a poem, which makes plain that the entire scene before had been a series of uses, a series of tricks, intended to mislead and obtain money from the judge. So the whole scene of the two women complaining about the husband was all orchestrated to get money from the judge. Using, of course, the most eloquent language. He further implies that in creating for himself the stigma of poverty, he had stolen money from the proud judges. His poem implies a sexual reversal in that the judge understands him as the weaker penetrated party. This reversal in turn opens the accusation of the man's wife earlier that he was the important character. Isa ibn Hisham, having heard this poem, replies with the legal maxim: the Qadi does not hear what is hated, al-Qadi la yasma'u ma yakra, and suggests that in his eyes it was better for him to have endured the cost of paying the wife's stipend and dismiss the couple from his presence than continue to permit this illicit speech. The Maqama concludes with the Qadi sending someone to learn the identity of the man. That's how Maqamat usually end. Whereupon he learns that he was the famed trickster Abu Bakr. His shameless eloquence has gotten the better of the judge, Isa ibn Hisham, and enabled him to live another day. So, analysis. I titled this section Legal Realities and Courtroom Dramas. Although this maqama is light-hearted, the appearance before judges portrayed in this maqama was a very serious procedure. It was the judge's moral responsibility to hear litigants and collect evidence from the plaintiff and the defendant. Moreover, as Matthew T.B. has noted, women's testimonies before the judges was often tense with difficulties. Judges and litigants had to contend with issues relating to quasi-public nature of the judicial procedure and its clear potential and for the revelation of intimate and scandalous details about the marriage. If a woman appears in front of the judge, it's going to be scandal. Given the topics of family law, women's appearances at court often had the potential of touching on two central issues: money and sexuality. TDA describes how and one area of women's concern was the repayment of dowry by the husband after the marriage and her receipt of marital support. Suing for repayment of the dowry was often a mode of provoking their husbands to divorce them. Common too was a claim that the husband was no longer providing marital support for the wife. According to Yosef Rappaport, up until the 13th century, the nafaqah was usually considered to be an in-kind stipend of goods, such as food on the table. As in this maqama, wives often sought assistance from the judge, placing him in the position of arbiter over the financial resources of the husband and the nature of his responsibilities towards his spouse. Both the questions themselves and the relationship of the qadi to these questions are on trial in this maqama. It could be argued, however, that an even greater inclination to scandal was the mere presence of the wife, her speech, and the potential for the revelation of sexual matters. As the notes, the jurist al-Khassaf goes to great lengths to describe how the delicate process of unveiling a woman in the court should transpire, such that while the qadi ought to see the woman, the less the other person saw, the better. One basic issue related to the capacity of the woman to leave her residence in order to lodge her complaint with the qadi. Fiqh books make it clear that only women who were of high enough social stature were able to visit the qadi. And this fact may have some bearing on the interpretation of this maqam as well. Scholars of Islamic law are fortunate not only to have the prescriptive evidence from legal manuals, but also to be able to consult court records contained in the Cairo Geniza. While conventional scholarship on the Geniza pointed to the common presence of women in court as evidence for the relatively high status of women, recent work by Zayed has argued, to the contrary, that women encountered great difficulties when they tried to seek justice in communal courts. Similar to what was mentioned above, Zinger stresses the nature of the legal questions raised, as well as the woman's very presence in the courtroom was a potential source of much scandal and shame. Other books offer further information on other dimensions of forensic dramas at most important. How do stories underscore the fears and anxieties of husbands about the impact their wife or wives appearance can contain might contain. This is something we don't find in football books, but in other books. For instance, there are several tales related to which a woman complains to the jurist Ashabi of her husband's ill-treatment of her. Learning of the ruling in his wife's favor, the man complains that she has seduced Shabi, she seduced the judge into unjustly judging on her behalf. There are other instances where the judge used to divorce the woman and he marries her himself. Other tales discuss the ways that marital disputations before judges, because of their potentially scandalous content, often contain testimony so indirect and vague that judges found themselves at a loss at how to pass judgment. In contrast to this, the litigant's speech in the Sharia is at times, however, frightfully direct, and this may also have reflected legal realities. For instance, wife number one claims in this maqam that her husband is not fulfilling his marital duties and that he is abusive and cheating. Male impotence honor was a possible ground for divorce. However, it was difficult often for his wife to prove this. Castration of a male, for instance, was immediate grounds for divorce, according to Hanafis. In cases of impotence, however, judges commonly instituted a long waiting period, in one case up to a year, in which the male would be given the chance to regain his rights. Related to this is the question of male willfully swearing an oath not to have intercourse with his wife for a certain period. In these cases, jurists consider the act to constitute harm, madarra, to a wife and would allow the divorce to be accommodated. See what I'm doing? I look at other works, how the fiqh was presented in them. I look at fiqh works, and I try to supplement what's not there, to get a full picture and see how adab is reusing this material to present. Other works of the 4th and 10th century considered cases of men with lack of desire for their wives on account of other reasons. In particular, an inclination for young boys is cited as a cause for impotence, presumably because the husband is not sexually aroused by his wife. This seems to be the implied connection between impotence and the desire to be anally penetrated in the wife's speech. As Khalid al-Wayl has noted, ubna was often understood as a disease in the case of grown men and treated thusly. Ubna was in the medical tradition believed to be a pathological desire that could no doubt cause a man so afflicted to not pay attention to his marital duties. Rabbi al-Isfahani relates numerous stories that discuss the relationship between Unna and Ubna. In one of his tales, the husband himself declares that he is impotent, both are used. So the husband declares that he is impotent and seeks the judge's intercession. After the judge subjects the man to test, he determines that the man is not impotent, but is only aroused by the young male servants of the judge. The judge then orders the man to resume his marital duties and stop chasing after the young male servants of the judge. In the case of the Shamiyah, the tale describes how the wife, through her accusation, tricks her husband by calling him impotent. He then responds by affirming his potency to such a degree that he claims to have such extraordinary potency that he caused her to abort the fetus. This, of course, then runs counter to his earlier claim that she was infertile. There is no shame that the litigants will not invoke that the dramatic speech leaves the party confused. This seems to be one of the central axes around which the courtroom ground turns. Elsewhere, I have analyzed this maqam not as a case of legal issues, but as a case for eloquence. Or because there are all sorts of literary themes, not only law, right? So one thing that is important for me is the fear of an eloquent woman, right? In addition to the fears and fantasies about the presence of women at court, and the fears about the contents of their speech, there was a pervasive anxiety about women's speech, as we have seen, the Sharia contains not one, but two elements whose powers of oratory seem to threaten the husband with public embarrassment or worse. Also, I was very much interested in the issue of kinaya. So, see, Abdul thought the maqama is inappropriate, cannot be published, cannot be read. But there is nothing inappropriate in terms of language, right? Not a single word actually that is foul language. So it's kinaya, you can translate it as autonomy if you want. It's to say something and mean something else, right? It's supposed to conceal, to hide. But here kinaya is used to reveal, not to hide. So between this concealment and revealing, the revealing and concealing is at play in this maqam. I'm not going to go into this. Conclusion, very short. Tanukhi and him, because there is so much and so many stories that I don't have a direct conclusion to convey to you. But Tanukhi's and Hamadhani's stories are different. They're very different. Tanukhi casts them as fictive akhbar with a proper Islam. Hamadhani casts them as invented fiction with a frivolous Islam. So they're totally opposite. But both authors reflect the urban Abbasid society. Of course, this is a culture of cities. Right? It's the urban Abbasid society and how hence both Islamic law and procedure appear naturally in them. The characters in the stories conduct business transactions, dispute with one another about debts owed, go on pilgrimage to observe religious rites and rituals, and when they die, they have the state distributed according to Islamic law. All of these stories impart lessons warning against unreasonable persistence, excessive greed, and false accusation. Literature, pre-modern and modern, even modern literature I think functions this way, is a very opportunistic art. Adab al-Usuli, riwayat Adab al-Usuli. Meaning, the literature or the novels, the modern novels, can use anything. They go and search for things, for material. So they have to study legal cases, they have to study medicine, theology, all sorts of things, right? And the use of Islamic law in these stories that I presented today is not exceptional. And I think this is not obvious. Thank you.
Questions? I'm sure there are questions that was quite thought-provoking, I'm sure. So go ahead if you have any questions, and I'll keep an eye out on the Zoom people in case anybody on Zoom wants to ask any questions. Either.
It's just a quick question, if you can hear me. Thank you very much. It's very interesting. I remember a few years ago you told me, you said at one point, I don't know how you described yourself, you said, I'm interested in so many things, I don't have one central thing I'm interested in. But it seems you're developing a theory of adab, which I think is really interesting. That's something that's germinating. I haven't heard you talk about that before. But my question is about Tanukhi, because I was reading another story a couple of days ago. It's weird how, it's weird how these central characters are so interesting. We go back to them constantly. And in that story, there's also a case, it's also a disputed legal case, and there's, torture is just part of it, right? Because you mentioned at one point this idea of torture and stuff. Torture is just accepted. In no way is it absolutely evidence. Torture is just kind of accepted as part of part of what you do, right? And it seems that in the story there about Shahadat al-Zuhur, it's also about class, right? About class, the fact that these
yes.
The weaknesses are servants. So I wonder whether, in addition to the presence of law and law procedure in these literary texts, what are they telling us about, because they're talking about the urban environment and especially the underworld characters in the maqama, what kind of, it's literature that's describing various social classes, right? So, and what is the presentation of those various social classes doing? How is it also reinforcing this kind of urban institutional culture that you described?
Beautiful, but it's complicated, right? We're aware of the complexity of the question. Of course, aggression, torture, all sorts of things appear in the work of these teachers. Because these systems do have. These people come to court and people talk about these cases. You're right, and cutting someone's hand, the famous story of cutting a girl's hand, for example, in torture, all of this. And you're right, you are linking to class, right? Because at the rich people or the upper classes, they're also fascinated about this lower culture. It's the underground. Think of it. You don't want to go to 3D. They command themselves, right? They're at for courts, for courtly culture, but they're obsessed about the underground, about the Banu Sassan, the beggars, this culture, the language too. Right? And I think this is what Adab also does, right? Because see, Adab and your question is a question of Adab. What is Adab? What does Adab convey? So, Adab to many people, to scholars in the field, they don't really understand what this is, right? Because it's not literature per se, but it's entertaining, it's educational, and you learn a lot. Their sources, historians love Adab because they're sources, but they have to be cautious of how much Adab to use, right? Otherwise they lose the historical aspect and their rigid sources. But also, it's a rubbish dump. When everything that's in civilization is considered frivolous or unwanted can simply be dumped, right? And they don't understand what Adab does as well. And I think what Adab does is this, it reflects, as literature also does, the aspirations of a certain nation, aspirations of these people, the way they look at their fascinations, right? We know about their fascinations of these Adab work, their anxieties, right? The anxiety of a fearful world. How do you actually find this if not in Adab work? Just the mere fact that there is a story about this reflects the anxiety of these male authors about this, right? This is what Adab tells us. I look at it as a social commentary on a civilization, something that you cannot study in the formal school system that is the madrasa, for example. But you're right, it's full of these, basically, isharat.
Just to add to what we're discussing, just to add to what we're talking about, for instance, how literature tells us about class and stuff. I mean, it's not just the literary narrative, but I think we can also get things out of it that were factual. Like, for instance, how Tanukhi mentions that he went to school with these 3 other boys who were, as you mentioned, poor boys, and he wasn't poor himself. So about these class dynamics played out in urban society, I think we can also get. But also to ask a question, what's your take on the applicability of these laws from literature, if I phrase that? Like how these laws are being applied, not just in theory.
It's a very good question, right? And it's a question that you will not find in fiqh books. The answer, you know that. Fiqh books, if you read any fiqh, there is that, how to pray, how to fast, etc. With all sorts of details, how to pay your zakat, all sorts of products, etc. And then you have the legal aspects, right? And they will give you the hudud, basically. This deserves a punishment of this. Right? You can go into courtly, if you go now to his modern, if you go to a court in the US, the judge does not actually give his opinion, that does not judge immediately. The judge looks at basically what other judges in similar cases have done. And these are documented. This is what we look at fatwas. But, so basically, also in these documents, you find the case and the judgment. You will not find these procedures. And I'm claiming here, and it's part of the bigger project also, with Intisar from Harvard Law School, because this is so rich, right? We know exactly how they asked for witnesses, how they questioned the witness, something you will never find in these four books. So we know a lot from these cases. Now, the applicability of the law, right? And I think Joseph Lowry talks about this. So I'm not a specialist in Islamic law myself. I studied it at a certain point in my life, but I'm not a specialist on this, and I don't have a law. But while reading this, Joseph Lowry has a very interesting statement where he says that the actually role of the law is not to punish you, but to get you out of the punishment. This is what the fuqaha are concerned with, how not to apply the law, right? They don't want to actually, no one wants to cut someone's hand and execute a jariyah or etc. As you see, the role of law is to actually get you out of it. And I think Thomas Bauer writes about this at some point also in his book, wonderful book, Islam as a Cultural Ambiguity, where he says that the whole this idea of hadd, right, hadd zina was applied in very few cases, I think in his work or something, in all Islamic history. Basically,
the law itself will take you out from the law.
Exactly, and that's the role of the faqih.
Because of the doubt, for example, in this case there was some sort of doubt, so the law itself will take you out from the law.
Yeah.
If you apply properly or through the proper procedure.
So yeah, it's here, and this anxiety of how to do it is a subject for adab. We see it here.
Yeah, I wanted just to elaborate on the relationship between the law and the first of all, I would sometimes when I read in Islamic law, particularly if you are talking about the judges and the cases and so on, you will find some people are using poetry or expressing themselves in poetry to comment or to express their feelings about the decisions made by the judges. So I think this is or could be considered one of the basic issues or basic point for meeting law and poetry as well. I was just reading today a little boy commenting on the decision made by a judge, and he was condemning the judge, expressing in fact his sadness and his concern about the decision and the impact of this decision on the future of the child. So I think this would be very beautiful.
Also concerned, not here, not in this lecture, but in general, I think about this thing, of how did the judges feel? You just said, right, that they would recite to power in sadness of the case. Recently I had a panel in the American Lit Festival with Sheikh Ashmawi, an Egyptian artist, who is a judge. And his novels are about legal cases too. Right? So I asked Ashraf, so I know that you use law and these court procedures and these stories that come to you as a judge in your novels. But how did your career as a novelist influence your case as a judge? He said, very much so. Because I'm a better human. And when I built my characters, this was his answer, I sympathize with them. Because characters have a certain logic. And criminals also have certain circumstances that led them to commit their crime. And he said, in one case, I judged and then I paid the penalty, he said. Because I sympathize so much with this person, but I had to actually judge him. So I gave him the lowest possible, basically, the sentence, and then compromise.
And some of the jurists, in fact, are very famous for their beautiful language. If you read, for example, Shafi'i in his book, Al-Risala, it's very technical. I mean, the book is very technical. But he is using a beautiful language also expressing his own feeling about the concept itself.
Yeah.
I was reading today one sentence for someone was describing the Qasr of Al-Muzani, and he was saying it will be still big or virgin and will never change. So the smile of the metaphor was very beautiful in commenting on the value of Qasr Al-Muzani.
Absolutely, and I
So
feel
this language also is full of expressing feelings and
right, which is very contrary to modern legal language, right, where you can find ulwa as a fa or a different how this changes the meaning, because we moderners are interested in having one meaning and a clear meaning, and we think that this is the purpose of the law, right? But of course, in these pre-modern, pre-industrial societies, they did not have this anxiety of what meaning. On the contrary, they celebrated the ambiguity of these texts that they can be interpreted differently. And a faqih was also obviously muhaddith, because this is how fiqh is derived, right, from Quran, from Hadith, the Sunnah, etc. So he had to master these, but also mastering these means mastering poetry, and mastering language, and mastering lexicography, and mastering all sorts of other disciplines. So you will not find a faqih who's just a faqih. That shows the bridges that I'm trying to emphasize also, the bridges between these different disciplines as well.
You mentioned the procedure done in Tanukhi called Istibhan. It was
Istibhan?
Istibhan.
Ifta'al,
Yes. Yeah.
Okay, Istibhan, where he looks in the Quran for some guidance. This seems like a very dramatic gesture, but it sounds like this is something Sheikh will do. I mean, can you talk about what this could be in reality? Would it be a dramatic event in a trial? Is this something alternatively that shows up in literature and poetry as a dramatic point?
A beautiful question. And do you do it here in Egypt?
Sometimes.
It's one thing personal. Like
I mean, I'm surprised that it's like a quality doing this, but I always think of it as actually a
Let me tell you something. Every single person does it. Every single. You know, I don't think I know a Muslim who doesn't do it. But also, I would. Right? That's how. By the way, that's how I went to Yale. I should not say this. But I said, I said, God will send me a sign today, whether to accept this offer or that offer. So good enough. My keys fell on the ground, and I looked at my keys, and it was written Yale. So I said, God said, I'm going to do it. But this is a sunnah. Right? You'll find it in hadith, you'll find it in the tradition. And traditionally, it's you open the Quran, right, and you read. There are other ways to do it. The istikhara, the salat al-istikhara, which is of course the whole type of prayer. You find it in the fiqh books, is that you pray 2 rak'ahs before you sleep, and then you wake up in the morning and see how you feel. That's also very common. But interestingly, also you find it in the tradition, in practice. You find someone opens someone's diwan. For example, Khalid Hafiz in actually Iran, right? So every morning you open the Hafiz Shirazi's diwan, you read it, and it inspires you, Khalid Hafiz. So yeah, we should talk about it. And whereas we need to understand also that we know the story not through a formal way, right? He is saying he felt something that's a very human thing that every judge will feel. So how he went about it himself, and that's what Adab actually also tells us. It's this anxiety that you will never find a fiqh book telling you if the qadi feels distrust or if the qadi feels unease, he should do this iftihad. But you will never find it. In practice, everyone does it. There wasn't.
Yeah.
First of all, thank you very much. My question relates to the sometimes ambiguous and like really out of context cases that we can find in books, especially from my experience, the shuruh of Matthew, for example, of a Matthew,
Yes, sure.
for example, and then a sharh of it, would have these very specific examples that are quite absurd. And as the reader, I wouldn't really know, like, how did this example come about? How did this case come about? And when we read things like Muhammad or literature or contextual histories, it gives more, but why is this not in the fiqh literature then? I find myself asking that question, like, how come this separation between the contextual happenings and what I see as the reader of a sharh or a fiqh book of these very specific strange cases.
Yeah.
So how do we bridge that? How do we?
I think it has to do with genres and how they work together. Right? A fiqh book is a very specific genre. It even has a very specific structure that they need to follow. Like the ibadat, the mu'amalat, the nikah, the mirath, for example, you have to follow a certain structure. And some things don't fit into this rigid structure. And fiqh must have this structure also because of the madrasa system. It's the curriculum. You need to learn this, then this, then this, right, in a very formal way. Adab is an informal network. So it does not have this rigid. No one will tell you this is how another book should be structured. Right? They're very different. They're very different. And anthologies might have, table of contents and certain structures, but they differ from one anthology to another. But also, the shuruh, you'll find them in the shuruh, not in the fiqh books. Because also the shuruh have a certain logic to them. So, an anecdote might appear in the sharh just because of the linguistic term that appear in this sharh. Right? They're marginalia, if you want. Shab with them. And you'll find it because, sometimes you'll find it because there is a common isnad, or there is a common name, there is a link to it. And that's why shuruh can be actually way more creative than the text itself. And they're much more interesting, because they have this subjective also tone to them. Right? And so I think it has to do with genres and how the genres play, function at play, basically. Okay.
Thank you for a very interesting lecture. So my question is about Sharia, and we talked about the frivolous isnad, and this is a very almost comical text, so it's fictional, it's a fictional story, and I just can't get over why would he do this frivolous isnad. Is this some sort of subversion of isnad as a tradition, or am I overshooting this here?
Look, to be honest, neither do I. I can't get over it, so I wrote a whole book trying to basically understand what this means. But, and people have commented about this. It's not easy for someone to fake an isnad in such an. People fake isnad, of course, all the time. Right? Most of when you hear Malik and Anas, that's mostly a fake isnad. Why do you do it so consciously by saying حدثنا عيسى ibn Hisham? It's like saying حدثني X from Y. Isa is a common name, Hisham is a common name, so why do something like this? You'll find, for example, I think someone writes about this. If you open hadith books, you find Isa ibn Hisham as a Rawi, but the source is after Hamadhani. So, right? And so you cannot actually use it in any historical way, but I think what's his name? Anyway, wrote Muhammad Nabi Zamani, The Art of the Pickaxe. The claim is that it's a pickaxe, the genre of pickaxe, it inverts things, right? Hero is not a hero. A hero kills, a hero sins, salvation through things, he's an anti-hero, right? Think of the Donkey Kong as a model. And by doing this, and that's his opinion, of course, not that I subscribe to this in any way, is to say that this genre is making fun of the Islam by doing this. It's a frivolous Islam, but also making fun of the whole genre of hadith and historical, basically, information and all of this. Another person, for example, Bilal Orfali wonders about this question by saying that there are ways of that how literature also functions. So what does Shahrazad say? بلغني أيها الملك السعيد. It's not hers, it's probably not as an actual authorship, right? بلغني أيها الرجل السعيد. But also how does كلمة ودنا start? زعموا أن, right? It's not my responsibility, it was relayed to me, so this is a literary tool, somehow. So probably, and this is also not my own opinion, this is James Monroe, by the way, wrote the Art of the Pickaxe, is by inviting you, right, to call your attention, to invite you that now this is going to happen and I'm not responsible about it. Or some other. There are all sorts of other theories also why Hamadhani was the system. Interesting.
Sorry, I don't have questions.
Comment?
Yeah. Thank you for your lecture. I was still thinking when you are talking, we have two kinds of language in our classical Arab literature. Two kinds of literature, two conceptions of literature. I'm not sure, but we have the poetry and prose. And I was thinking in the lecture, when you compare the novel to the classical Arabic, actually, you can compare novel with poetry. Poetry in classical Arabic. I feel that poetry on side and prose on the other side. And we are talking about prose.
Yeah.
Not all prose, because we have يعني الجاهل for example أو أحيانا التوحيدي الفرج بعد التنوخي all the مقامات. I feel that they are using language to how can I say هم أنا يعني ممكن أتكلم بالعربي أسأل أنا آسف. أشعر أن لدينا في الأدب العربي القديم نوعين من الأدب أو نوعين من مفهوم الأدب، ونحن طوال الوقت نفكر في الأدب باعتباره الشعر. حتى الآن نحن ننظر إلى الأدب باعتباره الشعر فقط، وإن هناك بحر كبير جدا جدا من الأدب كان القدماء يعرفون أنه أدب ويثقون أنه أدب. وهم يستخدمون. عندنا استاذ كبير جدا ما اعرفش حضرتك تعرفه ولا، اسمه عبد العزيز الأهواني، هو كتب عن هذه المسافه بين العاميه والفصحى، بين الادب الشعبي والادب الفصيح، وكان يطمح طوال عمره الى عبور هذه الحدود بين الاثنين. واحيانا وكتب مقاله بديعه جدا عن الفصحى في حرج في وضعها الحالي، وانه عليها ان تتغير لكي توائم ثقافه العرب طول التاريخ ليس الان فقط.
نعم.
وانه يعني
ده اللي عمله السعيد بدوي في
طبعا في المستويات طبعا، لكن هو كان بيفكر حتى في الادب، يعني في ما الذي ينسب الى الادب.
نعم.
احيانا كنت افكر في حتى في مقامات الحمداني ومقامات الحريري، ولما قريت عيسى بن شيخ كتاب الوحي الحديث انه في سخريه من لغه الادب، انه هذه ليست لغه طبيعيه. هم لا يريدون ان يعلموا الصبيان اللغه. قيل لنا والجماعه الذين قالوا انهم كانوا يريدون ان يعلموا الصبيان اللغه الحديثه.
قد يكون الحريري هكذا بس مش الهمداني.
يعني الحريري يعني مبالغ لا اكثر طبعا، لكن حتى الحريري انا وانا اقرا الحريري لا اشعر انه يستخدم لغه طبيعيه، هو يستخدم لغه ليسخر بها من اللغه الفصحى. انا اشعر احيانا انه يسخر من اللغه الفصحى، وانه بدليل انه حتى مقامات الحريري هي مقامات شعبيه جدا تتكلم عن وحتى الطريقه التي قدر بها قيمه مقامات الحريري كان ينظر اليها باعتبارها نوع من الادب الشعبي.
صح.
وانه ده جوهر الادب الكلاسيكي العربي. جوهر الادب الكلاسيكي العربي اللي بيمثله الحريري ليس بالفصاحه الباديه اللي هي ظاهره يعني، لكن ما في باطن هذه الفصاحه، انا اسف يعني، ما في باطن هذه الفصاحه من شعبيه.
حلو.
او من تصوير لجوهر الكلاسيكيه العربيه الحضاره، لان هو بيقدم المقام، يقدم المولود العربي كله حتى ألف ليلة وليلة، يعني حاجات بتجيب بعضها، حتى ألف ليلة وليلة هي أيضا تصفية، أو يعني مش تصفية، يعني خلاصة الحضارة العربية كما رآها مؤلفه ألف ليلة. يعني الخلاصة العامية بالصورة التي قدمتها حتى ألف ليلة وليلة، وهي بتستخدم الفصحى والعامية، شيء يستحق التأمل. أنا بس كنت بفكر وحضرتك بتتكلم إنه هل أستطيع أن أقارن أو أن أجد في الشعر العربي عند المتنبي مثلا ولا أبو العلاء ولا البحتري ولا كل الشعراء الكبار، هل أستطيع أن أجد هذه الصورة في العلاقة مع الشريعة الإسلامية؟ أنا شخصيا أشك إنه سأعتقد إن المسافة كبيرة جدا. بينما كتب النثر، أنا آسف أطول، بينما كتب النثر خصوصا عند بخلاء الجاحظ ولا عند ليالي الإبداع أبو حيان أو في المقامات المسافة. وبرضه في نقطة ثانية مهمة جدا وحضرتك بتتكلم عن المسافة بين الخيال والحقيقة. معظم الأدب العربي، وأنا بدرس لحسن حظي بدرس الأدب الكلاسيكي دلوقتي، إنه الأدب العربي الكلاسيكي كله قيل. يعني في رواية بلغني زي بلغني، يعني ليس هناك حقائق بالمعنى ده، وإنما هناك روايات. وروايات حتى طلب يسأل ولا حصل وما عرفش الكلام هو قيل. يعني دي نقطة كمان تستحق جدا العناية، المسافة بين الخيال والحقيقة في الأدب العربي. حلو، شكرا جزيلا. أنا آسف.
شكرا أستاذ خير، يعني منك دائما نتعلم وأنت دائما تضيف لنا على أمور كثيرة. بجاوب بالعربي والإنجليزي؟
بالعربي. يعني أنا آسف
خليني أتفق وأختلف. أنا أظن أن مفهوم الأدب أوسع بكثير مما علمنا في المدارس. وهذا الأمر موجود في تراثنا كله. كون آدم هنا استشهد بأدب. أنت أعطيت كورس على موكس، الناس الأونلاين كورس صح؟ بتاخذ حاجة كتبها شخص غير متعلم وأنت حللتها على أنها أدب، لأنه تضيء على مشاعره، على القلق الداخلي، كان شيء رحلة. هذا منظر. فمفهوم الأدب واسع جدا. هذا أجده في التراث. المشكلة فينا نحن في مدارسنا، في جامعاتنا، في مؤسساتنا، كيف ننظر إلى الأدب. يعني قسمناه على أنه شعر ونثر. ذكرتني بفولتير عنده مسرحية، واحد من البروتاغونست يعني البطل يقول للآخر: أريدك أن تقول شيئا ليس شعرا وليس نثرا. ويفكر إذا ما كان شعر لازم يكون نثر. These are categories. في الأدب العربي القصة أعمق من ذلك بكثير. لا يوجد تقريبا نص نثري لا يتدخل الشعر، المقامات واحدة. فهذا التزاوج بين الأخبار موجود في كل الوقت. لكن أيضا النقاد القدماء ونظروا على النثر والشعر والسجع كمنزلة بين المنزلتين، الجراي زون بين بروز اند بويتري. بمعنى أيضا إنه في مستويات لغوية، بس طبعا هذه كانت موجودة طبعا كل الوقت في التاريخ الإسلامي، لكن يمكنك أن تقفز من مستوى إلى مستوى آخر. كيف يعني؟ نظم النثر، نثر النظم، prosodification and versification. فعلي يقول مثلا إنه عندنا النثر والشعر، النثر والسجع والشعر، فعنده السجع المنثور مثلا تنتقل حتى من مستوى إلى مستوى آخر، والقرآن كمستوى آخر أيضا يمكنك أن تقفز منه من اقتباس القرآن. ففي عندنا أكثر من مستوى، كل الوقت الأدب يلعب بكل هذه الفكرة. هل بالنسبة لمسألة المقامات على أنها تعليم للغة، صح؟ أمضيت أنا يعني حوالي 20 سنة من عمري مع هذا النص. كل الوقت أحاول أن أبني النص. يعني this is what philologists do. كل الوقت يعني what we do in practice has nothing to do with this interpretation. This we do basically for lectures. What we try to do كل الوقت هذه نقطة ولا قاف ولا بس كل الوقت نحاول أن نبني هذا النص، لكن مع بناء النص يكون في بناء للشخصية، بناء للنص وبناء للشخصية وبناء للمجتمع ككل من خلال هذه النقطة اللي على طيب المقامات كعمل، أنا أظن إنه في نوع من التعليم بعد كل هذه الفترة، لأنه في بحث دائم عن المصطلحات. اللي بيشوف مثلا الحمداني في وصف الباب، في بحث، بس مش بحث عن اللغة فقط، بحث عن كنايات، بحث عن استعارات، بحث عن جماليات. لكن أيضا وهذا ما أريد أن أقوله، إنه الأدب وصولي، الأدب opportunistic، الأدب لا يحترم القواعد، لأنه سيستعمل كل هذا ليلعب بها نقد أدبي، نقد اجتماعي، نقد لوظيفته كأيضا أديب. يعني إذا فكر فيها كل الوقت، هذه دافين ستيوارت كل الوقت هذا الأديب، هذا الشحاذ هذا المكدي في المقامات يطلب المال، يريد أن يعيش، لكن كل الوقت يتكلم بأعلى مستويات اللغوية. كيف صار المكدي أرثى الطبقات الاجتماعية يتكلم أعلى اللغات؟ ودافين ستيوارت يقترح علينا أن هذه كلها ميتافور على هو الهمذاني، على وضع الأدب، على مأزق الأدب في تلك الفترة. الشاعر شحاذ، الأديب شحاذ في القصر. بعد حتى في أعمل الآن على مع أيضا زميلي موريس بومرانس على تحقيق الرسالة، مش رسالة المناظرة بين الخوارزمي والهمذاني، ونترجمها إلى الإنجليزية، وأظنها بوابة لفهم الأدب في تلك الفترة. في مكان ما يقول الخوارزمي للهمذاني: أنت شحاذ، والهمذاني يقول له: أنت أشحذ. أنت كمان شحاذ، مش بس أنا شحاذ. إيه؟ ففي كل هذا يعني في بحث، بس في مستويات كثيرة جدا 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 جدا، والهدف صناعة الفن. يعني أنا أنظر إنه كيف يصنع يعني في لوحات جميلة، كيف يصنع الفنان هذه اللوحة؟ في عنده تولز، عنده عدته كرسام من خيال ومن حقيقة مزوجة بين الاثنين. وهكذا أيضا الأديب يصنع التحفة الفنية بتزاوج بين الخيال والحقيقة والاستعارات ويوظف كل ما يحتاج إلى توظيفه لصناعة القطعة الفنية his masterpiece. صح؟ ويوظف أيضا الأدب السابق، يعني الأدب يشتغل الأدب. يعني الحمداني، أنا ما كنت تكلمت عن الموضوع اليوم لأنه كان هدفي الإضاءة على الإسلاميك لو، بس القصة نفسها اللي أنا قلتها أنا أدعي في مكان آخر إنه الحمداني سرقها من كتاب ذكر النسوة الوافدات على معاوية. امرأة تتهم الرجل بأمور معينة، وإذا وجدنا أنه درسنا المقام الأسدية للحمداني نجدها مأخوذة من التنوخي قصة الأسد. في كل تقريبا مقامة من الحمداني هي نتاج كتب مختلفة، لكن في إعادة كتابة، وهذا ما يفعله الأدب باستمرار ليولد نفسه، وهذا ما يفعله الكل. مش أنا بختين يقول في مكان ما كل يوم نتحدث بلغة أصلا قليلة والجاحظ يقول المعاني مطروحة في الطرق. صح؟ وهذا أيضا بنجده أيضا في الشعر. ومن هنا أرى أنه هذا الاهتمامات، يعني أنا أريد أن أتحدث عن the poetics of prose، الشعرية النثر. اهتمامات الشعر هي نفسها اهتمامات النثر أيضا، لأن التطلعات والانكزايتي وكل هذا القلق الداخلي موجود عند الأدباء. سؤال الأدب، من الذين رأينا ذهبوا؟ The Western question، صاحب اللاتن، ومن هو العدو؟ وأين كيف نستمر؟ هذا يمكن كعش. صح؟ الحمداني مشغول بهذا السؤال الكبير، كيف أغلب الدهر؟ كيف أستمر؟ متنبئ مهووس بهذا السؤال أيضا كل الوقت، معرفي مهووس بهذا السؤال، أيضا مهووس بهذا. هي الهموم نفسها. ولكن أيضا تعرف في فترات زمنية معينة في إضاءة على، أيضا سأستعمل الأدب كونه موجود أيضا في محاضرة آدم أعطاها في بيروت في عن الأنثولوجي. آدم is very provocative، دائما بيعمل is very provocative. فهو قال لنا أنتم كلكم هلا تدرسون الأنثولوجيا، هذه الأنثولوجيا كلها أصوات رجالية. نعرف أنه كان في شعراء نساء، أين هم؟ هذا الرجل تعالي مثلا كمثال أثبت أصواتا موجودة كانت موجودة. هذا الشيء ندرسه في النقد الثقافي كثيرا اليوم. صح؟ إنه ليش في شاعر يكون موجود وحاضر ويغير في فترة معينة إذا أحبب. نحن غيبنا هذه الأصوات، خلينا نتذكرها. القصيدة الكلاسيكية طفال نبكي من ذكرى حبيبي ومنزلي. صح؟ بعدين بيجيك امرؤ قيس قل لمن يبكي على رسم درس واقفا وضرب ربي انا جلس. ليش لا توقف وتبكي؟ خدك ترسم احلى makes more sense. ما هيك؟ بعدين بيجي شخص ثاني يقول ليس الوقوف، هذا هو ترجمة اظن، انت ليش توقف؟ خلينا نبكي نتذكر احترم انك انزل، غير المصطلحات. هذه الأصوات كانت موجودة على الدوام. الثورة، ذكرت الثورة على الدين في سؤال. أبو نواس استعمل إبليس كل الوقت، هو اللي قال شيخنا إبليس فخروا لها ركعا وسجودا. يعني حتى في القصيدة المشهورة اللي كلها استعمال للقرآن، أظن كانت دائما موجودة هذه الثورة والنزعة والاستعمال للتراث بمستويات عجيبة وغريبة وتزاوجات موجودة. لكن نحن نختار أن نركز ما يخدم أغراضنا نحن التعليمية، لأنه الاختيار دائما يهدف إلى شيء معين. وأنا ماني ضد أو مع ولست ضد تغيير الأصوات، ولست ضد الإضاءة على أصوات معينة، كلها تخدم أغراض قومية وتعليمية وإلى آخره، لكن أنا ما أريده أن نعي أننا نفعل ذلك ونفكر هل نريد أن نفعل ذلك أم لا. ومن هنا أنا كان اهتمامي أيضا محمد عبده his silence is text and his silence also هلا في هذا النص يقول لنا محمد عبده في نصوص أخرى محمد عبده مقهى شان مقاطع وشان مصطلحات وشان باراجرافز وشان شمول عجيبة وغريبة وإلى آخره. أنا مع أن نفكر يمكن ماذا كان المشروع القومي والمشروع الأدبي والمشروع التعليمي لمحمد عبده، وهذا بحد ذاته موضوع لدراسة بيكون جميل. بس شكرا أستاذ بعرف طلبت عليكم، بس السؤال كان يدعو إلى التفكير.
أي أسئلة؟
راح في مناسبتين، واحدة عن الشعر الصوفي وواحدة عن القرآن الحديث.
طيب شكرا.